Okay, learning objective 5 related homework. So the Securities Act of 1934. The Securities Act of 1933 and 34 contain which of the following? And the answer is both civil liability provisions as well as criminal liability provisions. C41, which of the following would be the auditor's most likely defense in an action brought under the Securities Act of 1934? And so again, what would they have to prove? Mystery or mystery. For A, the investor did not have privity. If it's dealing with recklessness or fraud, privity isn't going to be a good defense. The investor did not suffer a loss based on the materially misstated financial statements. So in other words, causation argument, that's a possible argument. D, the financial statements were not filed with the SEC. That's unlikely, right? Because the only time someone's going to bring a case is if it actually was filed with the SEC. So the two choices that we have to choose from are B and C, which says the auditors acted in good faith and were not aware of the materially misstated financial statements. And so again, the action is likely to be either fraud, which is what the provision is intended for, or possibly gross negligence. Um, so of these two, C is the most applicable because it's dealing specifically with fraud. It's not to say that B can't be applied to this scenario, but C is going to be probably the better of the two defenses. For C43, under the Securities Exchange Act of 1934, entities are required to report to the public about changing auditors on, and that is the Form 8K. In comparison to the burden of proof required for plaintiffs in civil suits against auditors, under common law, Section 10B of the Securities Exchange Act of 1934 is, as we discussed, the same in terms of proof of damages and losses. For C47, which of the following is a major difference in the auditor's liability in the Securities Act of 1933 in comparison to 34? And the answer is, well, they don't have to prove reliance under the 33 Act. And also, under the 33 Act, you can be found liable for ordinary negligence, and that is not the case for the Securities Act of 1934. So the best answer is both of the above, which is C. For C50, the Securities and Exchange Commission document that governs accounting in financial statements filed with the SEC is Regulation SX. C51, which of the following cases upheld the requirement that plaintiffs demonstrate scienter when bringing action under the Securities Act of 1934? And that is the case that we referenced, which is Ernst & Ernst v. Hochfelter. C52, a public entity subject to the periodic reporting requirements of the Securities Act of 1934 must file an annual report with the SEC known as, and that is the 10K, right? And lastly, C58, which states Donald's and Company, CPAs, audited the financial statements included in the annual report submitted by Markham Securities, Inc. to the Securities and Exchange Commission. The audit was improper in several respects. Markham is now insolvent and unable to satisfy the claims of its customers. Customers have instituted legal action against Donald's based on Section 10B, Rule 10b-5 of the Securities Act of 1934. Which of the following is likely to be Donald's best defense? And so again, it's the best defense. Because it's dealing with financial statements submitted to the Securities and Exchange Commission, B is not going to be a good one. Privity is not going to be a good one. And D, the engagement letter specifically disclaimed any liability. That's not going to be a good one. If you read the professional standards, they specifically state that you should not try and include any type of disclaimer related to liability in your engagement letter. But even if you were to include that, that doesn't absolve you of liability. If it were that simple, every engagement letter would just say, hey, we're not liable for anything if we're wrong. You just can't do that. And even if you do that and the client signs it, it still doesn't mean from a legal standpoint that you've avoided any kind of liability. So the best defense is going to be, again, saying that you did not intend to certify false financial statements. C73. Orange is a public company whose shares are traded on a national exchange, so it's a publicly traded company. A public company accounting oversight board inspection, so the PCOB inspection revealed a deficiency in audits conducted by Orange's auditor, LeGros. So this is some of that awesome accounting humor where you have an entity called Orange and the auditor's name is LeGros, like Orange is LeGros. It's not funny, but they think it's funny. So LeGros had failed to perform important auditing procedures. After performing these procedures in response to the inspection, LeGros identified several material misstatements and requested that Orange restate its financial statements. These restatements had the effect of reducing Orange's reported net income and cash flows from operations and increasing its liabilities. Upon the disclosure of these restatements, Orange's stock price declined more than 40%. Angered over the decline, investors are contemplating bringing legal action against LeGros for failing to detect the misstatements. So, assume that investors are bringing suit under the Securities Act of 1933. What would investors need to demonstrate to bring a suit against LeGros under this act? And so, again, to bring suit under the Securities Act of 1933, investors in Orange would need to demonstrate that, one, they suffered a loss, and two, that the financial statements contained a material misstatement. In addition to that, it would have to be a financial statement that was included in the registration statement. It couldn't be ongoing reporting for the company. For B, what is LeGros' potential liability to investors if LeGros audit was characterized as demonstrating ordinary negligence, gross negligence, or fraud? And so again, we're talking about the Securities Act of 1933. So under the Securities Act of 1933, LeGros would be liable for everything, right? So it doesn't matter what level we're talking about. And that's one of the reasons why it expands auditors' liability so much, is that now all of a sudden you're liable for anything, not just fraud or gross negligence. For C, it's saying do the same thing, but looking at the Securities Act of 1934. So we've talked about this a number of times. If you're bringing suit under the Securities Act of 1934, it's going to be under either the assumption that the auditor engaged in gross negligence or fraud. And so we know what those requirements are. They're misread. So under the Securities Act of 1934, that's what they're going to have to prove: mystery or misread. So material, scientific recklessness. Again, under Hochfelder, auditors may be held liable for constructive fraud. So it's not just fraud that can be held liable for. Reliance and injury. For D, what are the primary differences in LeGros' liability to investors under the Securities Act of 1933 versus Securities Act of 1934? And the two primary ones are what we just saw when we just compared the two. One, investors are not required to prove that there was a loss under the Securities Act of 1933. So there's no reliance required under the Securities Act of 1933. They only need to prove that they suffered a loss. So because of that, the burden of proof is going to shift to the auditor. In addition to that, part of the reason why the burden of proof is expanded is because under the 33 Act, you can bring suit for ordinary negligence. It doesn't have to be constructive fraud or fraud, which are more difficult to prove anyway. So that is it for the homework related to Learning Objective 5.